Andrea? Good morning, ladies and gentlemen, brothers and sisters of the media. Welcome to the weekly presser of the National Democratic Congress. Today, we will have our party leader, Senator, the Honorable Azimberg, take the press conference this morning. So without further ado, I'm going to turn you over. I trust everybody's ready.
Thank you very much. And let me start by saying a very pleasant good morning to all members of the media and to express my regrets for the short delay. And this morning, I want to make a few comments on a few things. But I want to begin by, first of all, extending special greetings and best wishes to our students who are returning to school today after many of them, no doubt, excited to continue to resume their education, to see their friends again after the summer break. Many of them, no doubt, be all set for school and have all the supplies and other bits and pieces that they will need in order to perform. Students are also going to be commencing school this morning. Supplies that they need. In particular, we have special concern about the lack of availability of books and school supplies for many of our students. We know that the government has been going back and forth on whether or not wishes to continue the free school books program that the National Democratic Congress had put in place some years ago, and which was a centerpiece of our government, because we felt that education must be at the heart of people empowerment, be at the heart of eradicating poverty. And so we felt that it was extremely important for us to provide an education or an opportunity for every person who wishes to educate himself or herself to do so freely and without being deprived simply because they could not afford to buy their books or to attend school because they could not obtain proper meals and so on. So this morning, we want to start by recognizing our students, sympathizing with those who are challenged, and the parents of those who are challenged, expressing the hope that the government would see the critical importance of paying greater attention to education, of educating our people, and through that, empowering our people and ensuring that Grenada can take its rightful place in the global community of nations. The second thing I want to make reference to this morning is to bring to the attention of the nation as a whole, to the media and to the nation as a whole, our plan to present to the nation a policy agenda for Grenada, Caribbean, and Martinique for the period 2017-30 and beyond. Our party has always maintained that while it is useful and even desirable for opposition parties to expose wrongdoings and criticize the conduct and policies of the government, never enough. More must be expected of a credible opposition. And so, in addition to criticizing, a credible opposition party must clearly set out for the scrutiny and evaluation of the public at large the alternative vision, the alternative policies and programs that it will implement following the general elections. Furthermore, it is our firm belief that it would be both wrong and undesirable to withhold our vision, our policies, our programs from the people and try to sneak it upon them, as it were, a couple of weeks before the general elections. Such an approach, we have said before and we repeat today, smacks of endorsement by ambush and can only serve to undermine the trust and confidence between those who are governing the country and those who are being governed. Something that is so necessary for effective governance through social partnership and consensus. And so, on the 22nd, Thursday, the 22nd of September 2016, the NDC will present its policy agenda for the period 2030 to the nation. We consider this a most important event, not only for the NDC itself, but for the people of Grenada, Carriacou, and Petite Martinique. Encourage as many persons as possible to attend that event. This will be a public event. It will take place at the Grenada Trade Center, and we are inviting as many persons as the Trade Center could accommodate. More will be said in the coming days and weeks about this, but we want to ask you, the media, to save that date, and we want to encourage you to let the public know, because it is time that the party lays out to the nation for the next 30 years. We hope to tell you during that engagement where we would like to see the nation positioned by the year 2030. But this is not going to be a short-term manifesto package of promises. It's going to be an outline of our vision for the country. And so that will happen on the 22nd of September at the Trade Center. And we're asking you at this point to save the date and to allow us to share with you, exchange with you, hear from you, and to get the word out. The third thing I want to make a few comments about today has to do with the constitutional reform and the referendum. The National Democratic Congress has not spoken recently on this issue in any detail. It's important to speak about this and to bring to the attention of the nation, so which we continue to share grave concerns about, and which we believe the nation ought to be. I want to start by saying that the National Democratic Congress once again reiterates that we agree with and will fully partake and support meaningful and substantial constitutional reform for Grenada, Carriacou, and Petite Martinique. We, of course, want to say, however, that central to meaningful constitutional reform, as we see it, is the requirement that there be input from the people and genuine participation by the people. The NDC is very serious about meaningful and substantial constitutional reform, and the fact that we are so serious is borne out by the fact that in 2010, the NDC administration engaged Professor Simeon McIntosh to lead a project culminating in the drafting of a brand new constitution. In fact, when Professor McIntosh suddenly passed away, the first draft of the new constitution had been prepared, drawing from the reports, constitution review commissions, and consultations that Dr. McIntosh had held. Extensive consultations on the draft constitution were about to commence. Professor McIntosh passed on, and of course the general elections came not so long thereafter. Administration indicated its desire to continue along the path of constitutional reform, embraced that process. In fact, without raising a single objection, the NDC fully cooperated with the current administration when it decided not to continue with the consultative process that had been started, or that was about to start, I should say, on the draft new constitution, but instead, the Constitution Review Advisory Committee, which has come to be known as the CRAC or the CRAC at that time. This approach differed from the NDC's. In the national interest, and with a genuine desire for all parties including the political parties, to work together on this national project, the NDC in effect made a compromise from inception when it joined the CRAC. That the ruling administration would make a serious and genuine attempt to fulfill the stated mission of the CRAC. And what was the stated mission of the constitution reform? I'm quoting here from the project document: to engender an environment conducive to reform of the Grenada Constitution, Order 1973, with the direct consultation of and participation by the people of Grenada, and thus make a national constitution which has the tangible input of the people, so as to build a better bonding between the people and the constitution. This is what was stated as the objective of the constitution reform process, as contained in the project document that was prepared by the government for presentation to the funding agencies like the UNDP. That's what they told the nation this reform was going to be about. As far as the NDC understood, the position of the administration and the CRAC was that it was going to be a transparent, credible, and people-centered process, so as to create an atmosphere of consensus among the people. The National Democratic Congress demonstrated how serious we took the issue of constitutional reform. None other than our former Prime Minister, Thomas, Stillman Thomas, as our representative on the CRAC. The NDC identified certain glaring deficiencies in the process. The NDC considered not to be in the national interest of the people of Grenada, Caribbean, and Martinique. We complained that the approach was driven by the self-interest of the new National Party administration and not by the interest of the people. The CRAC was not given the necessary resources to carry out its work, and you can see that from the reports by Dr. Alexis, or submitted by Dr. Alexis on behalf of the CRAC on the date of the 9th of July 2014, the first report that was submitted to the cabinet, in which Dr. Alexis complained in that document itself that no monies had been given to the committee to do its work. That itself was indicative of the lack of commitment that the government was giving to this exercise. At the same time, the NNP administration was manipulating the process so as to put forward to the people only those items that it was comfortable with, in many cases ignoring the expressed wishes of the people and insisting that the door was closed. This is what they told the nation at the time: the door was closed. In August of 2014, I made a national address. Deficiencies in the process, particularly the inadequacy of the consultations and the strong-arm tactics of the administration. In addition to the national address, the NDC published a position statement that was also submitted to the CRAC. The NDC communicated its concerns to the CRAC in several other written communications, all to no avail. After all this effort, and with no change from the committee. At the time that we withdrew from the committee, we made it absolutely clear that our withdrawal from the CRAC was not a withdrawal from the constitutional reform process. We continued to advocate for the wishes of the people to be respected and the items to be voted upon. Numerous deficiencies. We have listed many of them. Useful to mention a few of them today so that it will be very clear on why we have taken issue with this process and the way that it has been handled. Between February 26, 2014 and June 30th, 2014, the CRAC, according to its own report, held some 25 consultations around the country. Consultations had as few as 4 and 5 persons in attendance. muster 750 persons to attend these consultations over this period of 25 consultations. The administration did not give the CRAC the necessary resources to do its work. In fact, we were told the only monies that were given to the CRAC was a reimbursement that the individual members had paid for their trip to carry through, to hold a consultation there. As a result, there was never, ever sufficient consultation with the people. It did not keep or maintain any minutes or records of its proceedings. So nobody knows exactly who said what when, and whether or not what the committee is acting on in its recommendations, in fact, truly reflected the sentiments and the positions of the bodies that were represented on that committee. Devised a flawed internal voting mechanism to decide which items it will recommend to the cabinet for reform. Members sufficient time to consult with their constituents. The voting form was sent to them only one day before the date was actually set for voting. There was no system in place to ensure that members were voting based on a mandate from the various organizations and not expressing their personal views. There was nothing put in place to ensure that all members voted on all items. In one instance, only 4 persons voted out, 4 members voted. As a result, the recommendations coming from the people were not sent to the cabinet. Of the recommendations sent to the cabinet, some were rejected for no apparent reason, except that they did not serve the self-interest of the new National Party administration. In particular here, all the recommendation put to the cabinet by the committee after its retreat in October 2014, that a provision be included in the Constitution of the right to recall the representative if for any reason they came to the conclusion that the representative was unbecoming, that their character and conduct was such that they could no longer earn and continue to maintain or to keep the respect and confidence of the constituents who had voted them into office, and that the people should have the right, if those persons engage in criminal or immoral behavior of such great turpitude, to say, we want the right to determine whether this person should be called back or not. This was a strong recommendation coming from the floor out of the September 15 consultations of the Trade Center. This was a recommendation that was put to the cabinet by the committee following its retreat. The cabinet flatly rejected that recommendation without providing any reasons for its decision. The committee also recommended to the cabinet that the election and tenure of the Governor General should be provided for in the Constitution. It provided specifically, instead of having the Prime Minister as a single person choosing the Governor General, that the Governor General should be elected by a college of the parliamentarians coming together so as to ensure that the person who is elected as Governor General will not be partisan in their outlook, will not be viewed or seen as partisan, and can command the respect and confidence of members of the House on both sides. So that if at any stage the Governor General takes a position, it would not be seen as a party position. This, we felt, would have enhanced and strengthened the office of the Governor General and bring some certainty and predictability to the integrity of our constitutional arrangement. It was made to the cabinet by the committee, the PAC. Again, without offering any reasons, the cabinet rejected that recommendation. In fact, the cabinet pretended to accept the recommendation initially. The Office of the Attorney General's, the Office of the Attorney General instructions to go ahead and draft a law to that effect had been drafted. The Minister for Legal Affairs, Elvin Nimrod, then held a press conference in which he said, we are not going to go with that, again offering no reason for the decision. So this is what we have been facing, and I'm continuing with these defects and irregularities that have been a source of great concern for us. Furthermore, another round of consultations was supposed to have taken place after agreement was reached on which items were going to be taken to the referendum. That was not done. The bills were drafted and tabled and passed in the Parliament without consultations. In fact, the people were not even aware of what was in those bills. It means that while we made certain proposals for changing the Constitution, they were not given a say in how these changes were going to be expressed in the Constitution or in the referendum. As a result, this process has been flawed from the very beginning. And as we speak today, the vast majority of people in Grenada, and we can make this statement boldly, the majority of people in Grenada still do not know what are in those bills, still do not understand what are in those bills, and still are confused as to what should be put to the people and what they would be expected to do on Constitution Day. In my address to the nation on December the 8th, 2015, to postpone taking the bills a month and give the people a chance to scrutinize and discuss them before passing them in the Parliament. The call was flatly ignored. Interesting to observe that a similar call was made by the opposition leader of Antigua a few days ago, in which it proposed to the government consultations on a referendum that they too had set for October 27th. The Prime Minister decided to heed the call and the recommendation of the leader of the opposition the referendum from October 27th, the same day as our referendum, to May of 2017. In other words, another 6 months. We're not talking 2 days, we're not talking 3 days, we're talking about an extension, a 6-month extension agreed to by the Prime Minister on the insistence of the opposition leader, out of recognition that more time was needed in order to consult and in order to ensure that the people have an opportunity to fully understand and appreciate to vote on referendum day. There appears to be a mad rush to the referendum. The bills, as we said, were rushed through the Parliament. Now the government had to go back to make certain changes last week. Were published in the Gazette, and I'm referring in particular to 2 of them, the Name of State Bill or Act, and the leader of the opposition bill. What was published in the Gazette are different from what was passed in the Parliament. The CRAC put out a statement last Monday blaming the Princery and saying that it is the Princery that made the mistake, not the CRAC, not the lower house, not the upper house, not the cabinet, blaming the Princery for what has happened. Of course, in blaming the Princery, they referred only to one bill and said nothing about the second bill. They referred only to the Name of State Bill and made no reference to the leader of the opposition bill. With the mad rush, there is bound to be mistakes. And when it comes to constitutional reform, for mistakes, we must say in the Constitution, we must mean what we say, and we must say what we mean. We must check and double check to ensure that whatever is there truly reflects and represents the sentiments, the will, and the aspirations of the people. We know there is a mad rush because the irregularities, the flaws that we identified that caused us to pull out of the CRAC in the first place and declare that we could not support what was going on in constitutional reform at that time, continues today in its current form, unabated. In that regard, I want to bring 3 issues to your attention which I ask you to consider as members of the media. And I'm saying here, the irregularities and flaws are continuing, and I want to attention. First, the question of the authority to cause a referendum to be held. I want you to consider here, as members of the media, and to bring to the attention of the nation, is this: who has the authority in law to cause a referendum on the Constitution to be held? That is an important question. For the purposes of the referendum, the Constitution referendum, the Constitution referendum bill was passed together with the other constitutional amendment bills that were proposed when the Senate met back in July. It became law, this is the Constitution referendum bill, became law on the 12th of August when it was published in the Government Gazette. So the law that will govern how the referendum is going to be conducted was passed into law on the 12th of August of this year when it was gazetted, the 12th of August. This new of 2016 sets out the procedure for holding a constitution referendum, including how the date is to be set and how the date. I want to encourage you to pay attention to that bill because it does provide some very information and clear instructions on what is to be done. In that regard, I want to say to you that Constitution Reform or Constitution Referendum Act, it provides, and look at Section 4, it provides for the Governor General to issue a writ of constitutional reform under the seal of the state that will appoint the date on which the constitutional referendum shall be held. The person who has the authority in law for a referendum to be held is the Governor General. And she does so by issuing a writ of the referendum in the same way that she issues a writ for the elections. That is an instrument that will say will be held in the state of Grenada, Carriacou, and Petite Martinique on this day. That is the document. Only the Governor General has the authority to make that pronouncement and to issue such a writ. Of the law makes that very clear. To date, no writ has been issued by the Governor General, and as such, no date has formally been set for the holding of any referendum on the Constitution. It has been issued by the Governor General, and as such, no date has been formally set for the holding of any referendum on the Constitution reform. On the 29th of July, this was 13 days or 14 days before the Constitution Referendum Act was passed into law. Remember, I said it was passed into law on the 12th of August, and that is when the Governor General signed on to it, and it was published in the Gazette. That is when it became law. The law setting out the procedure to be followed on the conduct of a constitution referendum. That was passed on the 12th of August. On the 29th of July, some 13 days before the Constitution Referendum Act was passed into law, Dr. Alexis, without any express or implied lawful authority, purported to set the date for the holding of the referendum on the Constitution of October. To the best of our understanding, the CRAC and Dr. Alexis, individually or in his capacity as chairman of the CRAC, is not a body with legal authority as such. By its name and by its nature, it is an ad hoc committee set up by the Cabinet to consult with the public Cabinet on the matters of constitutional reform. In his report, dated the 9th of July, 2014. And I want to ask you also to encourage you to go back to his report that was published. This is the report that was submitted to the cabinet the 9th of July 2014 with the recommendations on what should be put into law. I want to encourage you to look at this report, and I also want to encourage you to look at the Constitution Reform, the Constitution Referendum Act of 2016 that we said was passed in August, and look in particular at Section 4 of this law. But in this report, Dr. Alexis sets out what he understood to be the functions of his committee. I want to point your attention to, in particular, to Section 4 of that report, Sections 4.1, 4.2, and 4.3. And this is what they say. The committee, I'm quoting here, a primary function of the committee is to continue the consultative process of constitution reform, leading ultimately to a referendum on the Constitution to ensure that further consultations be concluded within 9 months to 1 year. That was the first function. I'm still quoting. Another primary function of the committee is to provide oversight to the process of constitutional reform so as to ensure that the process is transparent and credible, creating the atmosphere of consensus that is presented as the second function. The third primary function of the committee is this, I'm quoting again. As the Grenada Constitution Reform Advisory Committee, implicitly, the committee is to advise the government on constitutional reform. That Dr. Alexis identifies as the functions of the committee as he understood it from the mandate that was given to him by the cabinet and regurgitated repeated here in this report. At paragraph 5.7 of the same report, Dr. Alexis sets out what he considers, or the committee sets out, what they consider to be the principal duties of the committee. And I want to read those to you as well. Quoting, primary functions, which we mentioned earlier, would have to discharge principal duties. And it goes on to say this. It would inform the public of the recommendations by the 3 earlier rounds of consultations. It would listen to and duly consider further views of the public on the matter of constitutional reform. The committee would share with the public the committee's own insights on the matter, pulling together the various emerging ideas on constitutional reform. The committee would advise the cabinet on the subject of constitutional reform. Cabinet, the subjects for constitutional reform which would be taken to the referendum, the committee would carry out public education on those subjects up to referendum day. End of quote. Nowhere functions, nowhere in its principal duties does Dr. Alexis or the members of this committee claim any authority in law to set a referendum date. He and the members of his team made this so-called announcement without even a member of the cabinet in attendance. Frankly speaking, that there would have been greater restraint in this regard on the part of the team of lawyers driving this constitutional reform agenda. After all, at least one member is paid as a constitutional consultant who is receiving a fat check at the expense of Grenadian taxpayers. It appears that the primary function for which this body was recruited was to give technical legal advice, but that function, it appears, has now given way to a marketing function. This preposterous act by the Governor General, only the Governor General can now rectify the situation by issuing a writ saying that what the true date of the referendum is going to be. She has failed or refused to do so. So I want you to consider why I say that these irregularities and these flaws are continuing even today as we speak. Announced the referendum has no legal authority whatsoever to announce anything or to create or cause a referendum to be held. The second issue I want to bring to your attention and ask you to consider is what is the expected role of the Prime Minister in the announcement of a referendum? Even though the Constitutional Referendum Act says that the Governor General will issue the writ, it is expected that the Prime Minister would announce the date after consultation with the Governor General. This is the convention that is followed announcements of elections. The Governor General will issue the election writ, yes, but it is the Prime Minister who goes to the nation and say, I have advised the Governor General that I want to dissolve the Parliament, and I'm asking her to issue a writ that elections will be called on X date or Y date. So the Governor General will act after consultations with the, but it is the Prime Minister who would normally say to the nation, this is the date for the election, and from what we're seeing from other countries, it is the Prime Minister who would also announce, this is the date for the referendum. Very quick research shows that the dates for referenda recently held in the Commonwealth countries were all announced by the Prime Minister of that country or his equivalent. In Scotland in 2014, Minister. In the Bahamas in 2016, that was the case. In the United Kingdom in 2016, the Brexit referendum, that was the case. I've not had an opportunity to look closer at the Bermuda referendum, but again, I feel confident that that was the case. Every single case that we have seen in recent times in a Commonwealth country, the Prime Minister does not abdicate his responsibility, but gets up and says to the nation, in which we are holding the referendum. The Prime Minister has been peddling this idea, have been staying out of the referendum process so as to keep the politics out of it. This, in our honest view, is nothing but a sick joke, and Grenadians must not allow themselves to be fooled by this. At the consultations held at the Trade Center, the people expressly called for the right of parliamentary recall and tenure of the Governor General to be included in the ballot. The committee met in retreat and recommended the inclusion of these items on the referendum ballot. Yet, they were dismissed out of hand. That is not a case of staying out of politics. This is a case of active involvement. And when his government announced through Senator Simon Steele, and they were taking no further recommendations from the people, this was not staying out of politics. So let's not pretend politics. The Prime Minister did not see fit to himself announce the date. This has to be the first time in the history of modern democracies that the national referendum is announced and the Prime Minister has delegated this duty to a body with no legal teeth, a body that is merely advisory. This, to our view, was a display of gross disrespect for the people of Grenada. Dr. Mitchell was quite happy to manipulate the process to get what he wants on the referendum ballot, but is not prepared to face the people to announce the date. It's not acceptable. The third issue that we want to ask you to pay some attention to is what is the real reason for the delay in issuing the referendum date, in issuing the writ for the referendum. The law says that, and I'm looking here again at the same referendum bill that I pointed you to earlier, that the referendum must take place not less than 21 days from the date on which, that the date fixed for the referendum must not be less than 21 days and not more than 90 days after the writ has been issued. In other words, it is an act which must formally confirm that a referendum on the Constitution will be held and set the date for that referendum. The writ can be issued up to 90 days before the date set for the referendum, but the writ cannot be issued less than 21 days set for the referendum. The Prime Minister has said there are no political considerations influencing the conduct of this referendum. It is already 5 weeks since purported to announce the referendum date on the 29th of July. 5 weeks since Dr. Alexis purported to announce the referendum date for the 29th of July, and yet the writ has not yet been issued. If there are no political undercurrents, what explains the delay? What explains the delay? If it smells like a foul and looks like a foul, then it's probably a foul. What explains the delay? If there are no political undercurrents, what explains the delay? 5 weeks have now gone. And what we're saying essentially is this: go ahead and set a date for this referendum before. The nation learned through a media advisory issued by the United Nations Development Program back in December of 2015 that the government had set a date of April 26th for the referendum. We learned this, the nation learned of it, because it accidentally came out in a media advisory issued by the United Nations Development Program. That the government will be trying to trick us with a referendum date, and perhaps it will not be the last. So we have to watch these things very closely, point out these mistakes, and we will continue to do so up until the referendum date, whatever that is. We will continue to speak on this. Other statements will be made in subsequent days by our party, but at this point, no date has been set formally for the referendum. And so we are watching like everybody else. Is that a date is being bandied about, and the people of Grenada remain virtually uneducated, consulted in a structured, comprehensive way to ensure that when they vote, they truly know what they're voting for, what they're voting on, and that whatever amendments are made to the Constitution will reflect the genuine aspirations, interests, and wishes of the people, and create a stronger bond between the people of Grenada, Carrick, and Peter Martin and the whole country. Thank you very much.
Your questions are invited at this time. Go ahead and speak loudly.
Thank you very much. Thank you very much for the opportunity to ask a question. I wish to the policy agenda that is planned for to be announced to the public on the 27th, 29th, sorry, 22nd of September, in that public event at the Field Center.
Can I just suggest that we are not just going to announce it, we're going to present it. So I want to, we're not just going to make an announcement, we want to present the entire document. And perhaps.
Okay, I take your point. Present it, engage, I would think, the public in what plans the party will have in regards to this policy. You said it's going to be presented as an alternative plan to what we now have.
Do we have a plan?
Yes.
I'm not quite sure if I said an alternative plan, but I'm saying we must present vision. I don't know if we have a plan. I don't even know if we have a vision. I can tell you that basically what we're saying is we should not simply criticize and condemn it.
Yeah. But talking about what alternative, and that's the point I really want to get. Alternative vision, alternative plan. It is said that both the NNP and the NDC are similar in nature. Would this policy plan that you, in what ways would it be different? I mean, one picture of a dozen is the same. Just a matter of the name change, the name difference. How different are you from the NNP?
Right. I would answer you this way. If I were to try to answer that question today, you would not come to the policy rollout. I'm pretty sure that you are there. So I'm not going to try to present that. But I feel confident that after the presentation on the 22nd, you yourself will be convinced that this is a different approach to governance. I want to say also that it would not be a fair characterization that we are all the same. The truth of the matter is, I'm not even quite sure that you have really had the chance to compare in an even-handed way how both parties are likely to go. In the last 21 years, for example, you've had one party in office for 16 and a half years, and you've had one party in office for 4.5 years. The party that is in government today has been there 4.5 years, 16 and a half of the last 21 years. And therefore, they have had ample opportunity, and surely much more opportunity, much greater opportunities, to present their vision, to present their plans, and to truly have an impact on the state of our country and the future of our country. So I am not even sure that we're making a fair comparison from that premise. But today, I'm not going to argue about that. I'm simply saying, please allow us the opportunity to make that presentation on the 22nd, and then agree with me or not.
It's in relation to this question. I know you don't want to let the cat out of the bag, but how different would it be the NDC and by transmission purpose? Would it be similar?
It's much more than that. It's much more than that. Yeah, you would see an expansion of the philosophical foundation on which the party proposes to develop its policies and programs, and you will see very specific policy guidelines. I want to call them that, guidelines, not prescriptions. You would not see that we are going to increase the VAT by 5%. You may see a statement like, we are going to review the tax regime in the country and make it a fairer regime. Yeah. In other words, you will know what we are tackling and what the policy objectives are. The specific prescription of the actions that we will take are more likely to appear in the manifesto.
You mentioned the date, but you didn't say a time.
Yes, yes, that is true. There will be a specific media event to deal with that. So the committee will, the chairman of the committee will date, the time and all of that. But at this moment, I was simply asked to encourage you to save the date. Yes.
As it relates to the referendum, right? You mentioned that only 2 were published in the Gazette.
I'm sorry, not that 2 were published. In the case of at least 2 of them that I have seen, what was published was not consistent with what was finally passed, I would say.
Okay.
As the opposition leader and the opposition party here in the country, do you think that you guys have a right to educate the people as well about the constitution reform process, go there and educate them about the bills, and not just on the committee mandate to do so?
We have a duty, but you see, the duty cannot operate in a vacuum. we have been making recommendations, they have been ignored. We do not control the authority. And we have to make a determination. If we say to the people, so that we can go out and explain and express themselves, and the government says no, right? We're giving you a month, for example, and we say give 6 months. In 6 months, I may be able to go around and do things and educate people. If you say a month, I'm not going to drop everything else and just decide all I'm going to do now is that for the next month, and that's my duty. That's why we're asking for more time, that it be done in a structured, balanced, responsible way, cognizant of everybody's circumstances and the people's circumstances as well. In other words, it cannot be expected that our responsibility now is to drop everything else and just focus on educating the people. That's why we ask for more time. That's why the leader in Antigua asked for more time. We want to play our part. We have been playing our part. I've held 2 or 3 national addresses on constitutional reform. We published documents on constitutional reform. I spoke for 3.5 hours on constitutional reform with a view to educating the people in the last parliament. When I appeared.
Well, 10 years close and still people are not educated about the fact. Do you think that, I would say, ask for more time for us to be?
Well,
and physical acts again?
Well, yes, I can ask, you can ask, the people can ask, we can demand it, we can demonstrate if necessary. I'm not calling for a demonstration, but keep in mind, the NDC is only one of the stakeholders in society. The NGOs, the trade unions, Media Workers Association, all of these bodies can let their voices be heard. Right? It cannot be that the government is doing what it wants. That will go along. And not only the NDC must speak about it, everybody must speak. Our business is to make sure you understand it. And if you understand it, write an article about it. Hold a news conference, something in the news about it. You have access to the media. You're part of the media. And when you speak, people are going to listen. So you have a role to play, I have a role to play.
Is it safe to say that you're calling for an extension to allow for more consultations to be held?
What we have said is what we intend to say today. We will issue other statements. So please, I don't want to say anything that I didn't say.
Technically, you're
asking for an extension.
Well, what I'm saying to you is this. It is clear to me that people do not feel ready. That's what I would say.
Can I ask for you to elaborate on that a bit, because press conference, recent NDC pressure, Mr. Vincent Wallace would have statements that when something like this, that there are certain things like in a particular bill or certain information in some of the bills that are being proposed for the referendum that cannot actually be enforced. Do you share that opinion? And can you say how and you're saying that from your impression or whatever, that persons are not informed. Can you just elaborate on how you come to that conclusion?
Well, we are hearing it everywhere we go. I'm answering the second part of your question first. I've spoken to many people who said, I really don't understand what is going on. I'm sure you probably have the same comments as you go around. So I cannot elaborate any further. I don't have numbers to tell you what said that or that was and what said that. But the general feeling I get as I go to talk to people around the country, we get the clear impression that people are not satisfied with their understanding of the bills and what they represent. Yeah. So that's how I would answer that question. The second thing I would say in relation to what our chairman, Vincent Roberts, spoke to, I would be very careful not to offer a comment on something I didn't hear myself. You know? Okay. I'm not so sure what he said, and I don't want to include it. But I can simply say this. There is a part of the proposed reform that speaks to what are referred to as directive principles of state policy. Okay, this is part of the reform that would say these changes are things that in enforcing, in interpreting and applying the Constitution, the judges and those who are charged with the responsibility to interpret and apply the Constitution of these principles, directive principles of state policy. Yes? For example, it may say, have regard for the national cultural heritage. When you make a decision, in deciding, for example, whether to, I'm giving an example, in deciding how a court would rule on Cameron Park or no Cameron Park, whether to allow the government to sell it or not sell it, if they say, and take account of the national heritage or cultural heritage of the people. That's a directive principle. But it is not something that you can enforce, because if the government take account of it and goes ahead and sell it anyway, do anything about it. That's what is meant when you say that you have directive principles that are not enforceable. I want to emphasize, I'm giving you this purely by examples. The directive principles, how the directive principles may operate. I'm not answering specifically what anybody said.
The issue of bringing politics into the referendum process, I guess, is a very contentious issue. You said a while ago that it's a sick joke to make that the PM that is taking out of politics, taking politics out of the process. How can we address? How can we remove that political stigma from a process that is as important as reviewing the supreme law of the land, the Constitution? And there seems to be that kind of uneasy tension about party and politics and so on and so forth. I mean, obviously there is a need for a national drive. How can we? How can we advise?
Well,
in terms of
yes, I mean, when we presented our national address in December last year, we reported to the nation that we really wanted genuine constitutional reform. We believe it was important that it be done consensus rather than the two parties fighting over the issues. That it was clear that we could not reach a consensus in the present situation because we felt there were things that should be on that were not on, there were things that the people recommended that were ignored, and that it really was what was being done. And we said so. We said we saw the importance of arriving at a consensus, and we felt the best way to achieve this was to bring in a body that had no axe to grind, whether it was the United Nations, the NDC, Organization of American States, or the Institute for the Advancement of Democracy, IDEA, the Commonwealth Secretariat. Bring in somebody who had no axe to grind, or a group of bodies who had no axe to grind, to see if they can facilitate accommodation, some kind of middle ground going forward. That was a concrete recommendation. Not only did we suggest that, but we actually wrote to some of the bodies. Not everyone responded to it, because I think part of it is that an opposition party writing to somebody like that without also want them in, you know, to respect for the sovereignty of the state and the authority of the government. They would not want to be interfering if the government does not buy in. It does not buy in from the government. So at the end of the day, we made the call in that document as well, in that statement as well, calling on the Prime Minister to delay the debate in the Parliament on the bills and engage some of these bodies so that we can try and facilitate a better outcome. So this was a very concrete recommendation on how we think that you asked.
Okay, apart from this press conference yesterday, and apart from this press conference, how do you, as the opposition leader and the opposition party, or even get the government extend, try to get the government to extend time of this referendum process?
I'm sorry?
Are you gonna try to educate people more about the constitutional reform, or try to get the government to extend the process of going to the vote, going and vote on the votes and stuff?
Well, I mean, there are different, some of that may involve radio appearances, television appearances. It might mean repeating, recording, broadcasts, doing them over. Right? Remember, as an opposition party, we do not have a tremendous amount of resources. Yeah? And so we have no money to be running up and down the country trying to be the government. That's why people pay taxes, so that resources can be used for the education of the people. It is important that we do not shift this responsibility onto the opposition parties or the stakeholders or the business community or the trade unions or the Media Workers Association. This primary responsibility onto them. The government of the people's purse, and the government are the custodians of the state, the apparatus of the state, the machinery of the state, and the direction of the state. They are in authority. Excuse responsibility, we must call on them to do what needs to be done. I'm encouraging you to speak up. Join us. Let's hear many voices, because sometimes the strength of numbers that I think you're asking a very legitimate question. Don't misunderstand me. The opposition has a role, right? So I accept that. But I'm saying to you, my dear sister, the government feels that they are in charge and they're not listening to anybody. So we have to bring the strength of numbers. We have to bring many voices from many quarters making the same demand.
One last question I observed that in the proposed changes, recommendation for the reform bill, one of the 18 recommendations that were made had to do with the will of the people, the will of the people. And as I understand it, it should be the will of the people that will drive the process and that will create whatever. I just wanted to kind of hear from you. I know you have some legal background. What do you understand to mean the will of the people in the context of a constitutional reform, the will of the people?
Well, in the context of constitutional reform and in the context of governance and democracy, it really means the same thing, that those who are governing the country are presumed to have been elected by the people of their own free will and as their choice, because they believe that these persons are best suited to act in their interest and on their behalf. These persons, once elected, are not there at their own whim and fancy, are not there to advance their own selfish objectives or purposes or designs. They are there to take such action that will be most consistent with the interests of the majority of citizens. Yes? So you cannot be acting, it is anticipated, therefore, that that authority must be listening to the people, must take the time out as a duty to hear from the people. What do you want? What do you think? What do you believe? These are that must be attended to if you are going to be acting for them on their behalf and in their interests. collective idea that we capture as the will of the people. In other words, observing the will of the people cannot be an accident and should not be an accident. It must not happen, or one should not be trying to do it, independent of consultation with the people. Saying that if the people are asking you to please put on the ballot a question regarding how the Governor General is elected, and the committee that you have appointed to advise you put that to you as a recommendation saying, we went out, we talked to the people, and this is what they want. Why would you not put it on? It's a question. It's not a decision that you're making. Put it as a question and let the people say no or yes. It's only a question. Why are you afraid to put that question on? It's only a question. Add it. Well, it's too long and too many. Initially, that's what they said. 12 is enough. But how do I know 11 is not? How do I know that 13 is too much? What is so magical about 12 to say that we must only have 12 recommendations and we don't want to put any more? It's an excuse. Only 12 is enough. Who gets to decide which 12? Is it more important to add the EMPT magnet right now than to give the people a character self-governance? I mean, I don't know. I'm just asking which is really more important at this stage? Is it more important to change the name of the Commissioner of Police from Chief of Police to Commissioner of Police that will limit how the Governor General is elected? How do you make that choice? And do the people have any say in how the choice is made? These are the questions. Go around pretending that NDC is trying to politicize the thing and NNP don't want to politicize it and so on. This is a very cheap and dishonest to approach the situation. These are real concerns. We have them. And we too want to ensure that the thing is as apolitical as possible. We want to keep the politics out on a way to do so. You cannot be using strong arm tactics to have your way and at the same time just trying to keep politics. That's not fair and it's not right. Okay?
You know, Senator Brown, somebody would ask the question, what if the recommendations that that's the NDC would have made would have been included in the referendum, if there would be a difference in maybe, you know, how the NDC is viewing the whole process? What would you say to that?
Because what is that issue really? The fundamental concern that we have is twofold. One, recommendations of the previous commissions and bodies are not being observed. It's not the NDC's recommendation that you're making this point. It's not the NDC recommendation. Go back and look at the history. You're going to see it. In the parliament, I read out the actual pages from which all of the recommendations came. From the 1985 report, from the 2006 report, from the 2010 report. I'm not making this up. So is it not fair to say to the recommendations of the NDC and the NDC vexed because we didn't get what we want? That's not an honest representation. And I'm sure if you look at it, you're going to see that.
Just one
okay.
Just one question. Who has that authority to determine which are the bills that are most important at this
The
time?
cabinet. Okay.
Well, there being no further questions, thank you very much for coming out today, and we look forward to hosting you again next week. But I'm sure there are going to be many more issues for us to address. Thank you very much again. Have a great one.
Yeah, he does. He's recording. Yeah, he would send it from there. So I want to call. You want me to send directly to you? Or when I get to the send it? No, I'm not getting that.
yourself. So if you foundation to directly